Typically, the second stage of the international patent process involves filing a PCT International Patent Application. Often this PCT is linked to the priority date of a provisional patent application filed before it, but not always. A PCT can be filed with IP Australia in the first instance. The PCT process is a process that allows a single application to be filed, but at the same time creating a filing within 150 member states by that one filing. So it's a sort of a way of centralizing the patent process for another 18 months after the first 12 months of the provisional application has elapsed. All in all then, 12 plus 18 is 30 months or two and a half years. And so it allows inventors or innovative companies a 2.5 year period in which to decide in which countries they ultimately want to pursue protection, and that's in the third stage of the process. I'll now describe the PCT process and its steps chronologically from the point in time in the PCT is filed, but the dates at which these, or the timing at which these steps occur, are calculated as time elapsed from the original priority date of the provisional patent application. So the first action that the applicant will receive is an international search report issued by the International Searching Authority, and accompanying that a written opinion of the International Preliminary Examination Authority. These documents are received at 15 months after the priority date. There is an opportunity to lodge claim amendments called Article 19 amendments in response to this written opinion. But where the written opinion raises more than just novelty objections, for example, inventive step objections, it's quite usual for applicants to engage in a more substantive examination response process, which I'll describe in a moment. But the second step in the PCT process is publication of the PCT specification, the search results, and the written opinion, and that occurs at 18 months from the priority date. The third step is this more substantive examination. It's called International Preliminary Examination, and it commences with lodgement of a demand before the 22-month date, again calculated from the priority date. During this process, it's normal to make claim amendments or arguments in response to the examiner's written opinion. And sometimes there's 1, 2, or even 3 rounds of argument or claim amendments with the examiner to try to persuade the examiner as to the patentability of the invention, with the hope to have the examiner issue a clear international preliminary report on patentability.